It is the 14th of August, 2013, a federal courtroom in New York City. Judge Shira Scheindlin sits at the bench and reads a 195-page opinion into the record. The New York Police Department, she finds, has been systematically violating the constitutional rights of hundreds of thousands of people. The city does not go to jail. Nobody does. This is the story of how America built a system designed to fail, and who profits when it does. The United States incarcerates more people than any other nation on earth, not per capita, in absolute numbers, more than China, more than Russia. On any given day, approximately 2.3 million people are held in American jails and prisons. In 1970, the American incarceration rate was 161 people per 100,000. By 2008, it had reached 756 per 100,000, the highest ever recorded for any democracy in human history. Something happened between those two numbers. Several things, in fact. They did not happen by accident. In June of 1971, President Richard Nixon declared drug abuse public enemy number one. His aide John Ehrlichman would later explain the strategy in terms its architects never used publicly. By associating the left with marijuana and black people with heroin and then criminalizing both heavily, they could disrupt those communities. Mandatory minimum sentences removed judicial discretion. A conviction for possessing 5 grams of crack cocaine carried the same mandatory sentence as possessing 500 grams of powder cocaine. That 100-to-1 disparity remained federal law for 24 years. The Fair Sentencing Act of 2010 reduced it to 18-to-1. It was not made retroactive. By the mid-1980s, the war on drugs had produced a problem. American prisons were full. States were running out of space and money. A solution arrived in 1984 in the form of a company called Corrections Corporation of America. Its founders went to the state of Tennessee with a proposal. Let us run your prisons for you. We will do it cheaper, and you can pay us per prisoner per day. Tennessee passed. The private prison industry had been born. The business model is not complicated. A private prison company signs a contract with a state or federal government. The government agrees to pay a daily rate for each prisoner housed. The company's profit depends on 2 variables, keeping costs down and keeping beds full. The industry calls the second variable the occupancy rate. Some contracts include what are called lockup quotas, guaranteed minimum occupancy clauses that require the government to keep the prison at 80, 90, sometimes 95% capacity, or pay the difference regardless. If the crime rate drops and fewer people go to prison, the taxpayer still pays for the empty beds. This is the system's first design feature. It does not benefit from less crime. Corrections Corporation of America, now rebranded as CoreCivic and GEO Group, are the 2 dominant players in the industry. Together, they operate more than 170 facilities and generate combined revenues exceeding $4 billion per year. They are publicly traded companies. Their shareholders include pension funds, mutual funds, and major institutional investors. Both companies spend heavily on lobbying. Between 1999 and 2009, CCA spent approximately $18 million lobbying federal and state governments. They lobby for legislation that increases sentence lengths, expands the definition of criminal offenses, and limits early release programs. They fund organizations like the American Legislative Exchange Council, ALEC, which drafts model legislation for state lawmakers. Among the bills produced through this pipeline, mandatory minimum sentencing laws, 3 strikes laws, and truth in sentencing laws requiring prisoners to serve at least 85% of their sentences before eligibility for release. The industry does not write these laws in a vacuum. Elected officials in states with large private prison facilities receive campaign contributions from the industry. The pipeline runs from the state house to the contract. Inside the facilities, the cost-cutting takes specific forms. Private prisons spend less per prisoner per day than public prisons. Fewer staff, lower staff wages, higher staff turnover, less programming, less medical care. A 2016 report from the Department of Justice Office of Inspector General found that federal private prisons had higher rates of assaults, both prisoner on prisoner and prisoner on staff, than comparable federal public facilities. They had more contraband, more lockdowns, worse outcomes. The recidivism rate, the percentage of released prisoners who return within 3 years, hovers near 70% nationally. Private prison companies do not profit from rehabilitation. A prisoner who completes a vocational program, finds employment, and does not return is a lost customer. The second population the system has industrialized is immigrants. ICE detention beds rose from approximately 20,000 in 2001 to more than 52,000 by 2019. Roughly 70% of those beds are operated by private contractors. GEO Group and CoreCivic hold the dominant contracts. The detained population is not convicted of crimes. They are held in civil administrative detention while their immigration cases are processed, a process that can take months or years. They have no right to a public defender. Many do not speak English. Some are held in facilities in remote locations, hours from any legal service organization. The workers inside both criminal and immigration detention facilities are often the prisoners themselves. Federal Prison Industries employs federal prisoners at wages between 23 cents and $1.15 per hour. The 13th Amendment to the United States Constitution, which abolished slavery, contains an exception. Neither slavery nor involuntary servitude shall exist in the United States, it reads, except as a punishment for crime. The exception is still in use. The industry has attracted critics from across the political spectrum. Fiscal conservatives argue that private prisons do not actually save money when accounting is done honestly. Civil libertarians argue that delegating the state's power to deprive citizens of liberty to profit-seeking corporations creates irreconcilable conflicts of interest. Criminal justice reformers point to the recidivism numbers and argue the system is not malfunctioning, it is functioning exactly as designed. In 2016, the Obama Justice Department announced it would phase out the use of private prisons for federal inmates. The stock prices of CoreCivic and GEO Group fell sharply on the news. In 2017, the Trump Justice Department reversed the decision. The stock prices recovered. The 2.3 million people inside American detention on any given day are disproportionately black, disproportionately poor, disproportionately undereducated, and disproportionately from a small number of specific zip codes in a small number of specific cities. The communities they come from have been stripped of working-age adults, tax revenue, parental figures, and institutional trust in the legal system that put them there. Their children are statistically more likely to end up in the same system. The industry calls this the pipeline. Researchers call it the school-to-prison pipeline. The companies call it the addressable market. There are 2.3 million people behind that number. But the question the system has never seriously attempted to answer is a simpler one. The private prison industry in America generates $4 billion in annual revenue. That money comes from somewhere. It comes from taxes. It comes from contracts signed by elected officials. It comes from pension funds that most Americans are invested in without knowing it. The next time you check your retirement account, you may already be a shareholder. This is the system's second design feature. It is politically durable because it is financially useful to the people who make political decisions. The next time you check your retirement account, you may already be a shareholder. There are 2.3 million people behind that number.